The Judiciary in Hawaiian Affairs called to order. It's Tuesday, February 8th, and we are in conference room 325. First up, we have HB 1208, House Draft 1. Tom Yamachika, Tax Foundation of Hawaii.
Thank you, Chair. Members of the committee, Tom Yamachika from Tax Foundation of Hawaii. We submitted written comments. We also wanted to add that this kind of brings back the situation a few years ago when, at the urging of the Hawaii State Teachers Association, there was a CONAM proposed to allow the state to surcharge real property tax. The counties brought up the point that because that proposed constitutional amendment would impact their main revenue stream, they were looking at a downgrade of their bond ratings, and all of that would entail. So we would expect the same consequence to happen here. I'd be happy to answer any questions. Thank you, Chair.
Okay, thank you very much. Will White, Hawaii Appleseed Seller.
Thank you, Chair, Vice Chair, members of the committee. My name is Will White. I'm the director of the Hawaii Budget and Policy Center, which is a program of Hawaii Appleseed Center for Law and Economic Justice. We're submitting testimony in support of this bill today, mainly because it would create a pathway for the state to realize additional revenue for some really critical public services. Hawaii is repeatedly ranked as having the lowest real property taxes of any other state in the country. And this really makes us an outlier relative to other locales with high value real estate markets. Additionally, these low tax rates make our housing market incredibly enticing to wealthy out-of-state investors and owners of second homes, which can have an unwanted effect of increasing housing costs for all of us. We are very cognizant of the fact that an increase of taxes can be burdensome for local residents who are already struggling with a high cost of living. So we would encourage the legislature, if this were to pass, to target any increases in property taxes to owners of second homes and owners of investment properties. That would be a far more equitable way to distribute the tax revenue. And it could also be a way for the state to generate some really significant revenue for our public services. So for that reason, we are supporting. Thank you.
Thank you very much. Okay, members, that's the only testifiers you have scheduled for today. Are there any questions from members?
Chair, Ward, have a question.
Representative Ward.
Is Tom Yamachika still there? Tax Foundation?
Yes, Representative.
Who's the highest taxed in the nation?
I believe we are, sir.
Or New York, or what? We're number 1, 2, or 3.
Yeah, we're way up there.
So how much more do you think we can squeeze out of the people, given this, giving the states now what otherwise we had given to the counties? What do you think that they would do in terms of the actual implementation of it, if it did pass? In other words, what can my constituents expect if this thing passes?
I think what's going to happen, Representative, is that lots of people are going to go on planes and get the heck out of here. We've already seen from the U.S. Census that we're losing more people. We've kind of gone down that path for the last few years, and this wouldn't help. I'm sorry, Representative, I can't hear you.
What have the counties done wrong that we would want to do a clawback in terms of their exclusive right to do this? They haven't raised the taxes enough. I mean, one of the testifiers said, we're the lowest taxed in the nation, which is the only tax deal that we've got so far, which this bill obviously would take away.
Well, you would have to ask that testifier, Representative, but personally, and from the viewpoint of my organization, I think we were, taxed quite enough already.
Taxed up to the gills. If you add it all together between the state, the feds, and other things, what is the percentage of the taxation that the average Hawaii resident would be paying?
Well, that depends on a lot of things, Representative. The percentage depends on your income level, because the income tax is graduated, whereas other things like the GET are not. So it does vary quite a bit.
Okay, Tom, thank you. I look forward to seeing you in person. You've been consistently a testifier, but now you look like a airline pilot with your with your goggles on. Thank you for testifying. Thank you, Chair, for the ability allowing me to.
Members, any other questions? Okay, seeing none, we will move on. House Bill 12, oh, I'm sorry. House Bill 1209. Director Isaac Joy.
Yes, Chair. Jonathan White on behalf of the Director of Tax. We provided testimony providing some comments on the bill, and we'll stand on our written testimony. Thank you.
Thank you very much. Nicole Wu, Hawaii Children's Action Network.
Aloha, Chair, Vice Chair, members of the committee. I'm Nicole Wu from Hawaii Children's Action Network Speaks, and we submitted testimony in opposition to HB 1209 because it would repeal the state's personal income and corporate income taxes if the property tax constitutional amendment in the prior bill passes. And I hope you'll take a moment to look at my written testimony. It has some charts that help explain how when you look at our state and local tax system here in Hawaii, our lowest income families pay more than those at the top. We actually have the second highest state and local tax burden on low income people in the country. That's mostly because of our GET tax, and there's a chart showing how it's more extreme, and that's the cause of most of the regressivity. And then it also shows how the personal income tax is the part of our tax code that pushes back against us. It taxes those who are higher income more than those at the lower parts of our income spectrum. And that's something that we really need to maintain unless we want to make it even harder for working class families to live and stay in Hawaii. As a children's organization, we also focus a lot on the personal income tax credits that so many families rely on. At tax time, they can apply for our earned income tax credit, our renter's tax credit, our food excise tax credits, and actually get some money back. And this is part of the personal income tax system, and it's a very important tool to help families, make their rent and pay their bills. We've seen from the federal stimulus payments and the child tax credits at the federal level in the past 2 years that when families are no longer or not required to file income taxes at all, that they miss out on these kind of tax credits and payments. Our organization's been doing a lot of work to reach out to families to make sure they're getting access to these payments. And it's so much harder when they're not in the income tax system. So, and then also with the corporate income tax, I was looking at some DOTAX analysis, and they say that nearly 60% of our corporate income tax is paid by non-resident corporations. So, we hear a lot of talk about, we want to make sure this tax asks those people who don't live here or don't have their corporations located here to pay for, benefiting from these beautiful islands. And it seems like the corporate income tax is one of those most effective tools. So I really urge caution to legislators before thinking about repealing the personal and corporate income tax systems, because there are a lot of benefits to them. Thank you.
Thank you very much. Next, Tom Yamachika, Tax Foundation of Hawaii.
Thank you, Chair, members. Tom Yamachika from Tax Foundation of Hawaii. We have written comments, and we will stand on those. It's basically the same general testimony as for the previous bill. I'd be happy to answer any questions.
Okay, thank you very much. Will White, Hawaii Appleseed Center.
Thank you again, Chair. We are submitting testimony in opposition to this bill. Like the previous speaker, or one of the previous speakers said, our tax system is incredibly regressive, largely due to the general excise tax. And the income tax is one of the saving graces of that, and actually makes it more progressive, or helps to counteract the regressivity of the general excise tax. Hawaii households earning $20,000 or less pay 0.6% of their income on income tax, compared to the top 1% of earners who pay 6.2%. Additionally, corporate taxes are a really effective way for generating revenue for the state. I'd also like to point out that the corporate income tax at the federal level was already significantly reduced by the Tax Cuts and Jobs Act. So corporations that are turning a profit are already seeing a benefit from that. Again, we would also urge caution when thinking about repealing or refunding corporate and income taxes. For those reasons, we are opposing this bill. Thank you.
Thank you very much. Will Karen.
Aloha, Chair, committee members. Will Carone testifying as an individual in opposition to this bill. As was mentioned earlier, there is a high tax burden here in Hawaii, but it's all about who's paying that burden and in what kinds of taxes. And when you look at the types of taxes, as was mentioned by several other testifiers, the income tax is the only tax that we levy that's actually progressive, that takes a larger share from those with lots of money than it does from folks who are struggling to make ends meet. So when we're talking about the tax burden, it's really important to zero in on what kind of taxes we're talking about, and getting rid of the only tax that actually helps working families by offsetting or by not taking more from them than they ought to be paying, the way that the GET does. We would be making the tax burden much harder on folks who are already struggling. Folks who are doing well, I think, can afford to pay a little bit more, but folks who are at the bottom are already struggling, and getting rid of the income tax would pretty much only be helping the folks who are already doing well. And it wouldn't do much at all for the working folks. So I think the trade-off isn't worth it. I think that the income tax is something that we should hang on to. I don't necessarily have a problem with the state levying property taxes. I think if the state wants to do that, then fine. But I don't think we should be getting rid of the income tax as a trade-off. So thank you.
Okay, thank you very much. Yes, all the testifiers you have scheduled for this bill. Members, any questions? Okay. Seeing none, I will hand it off to Vice Chair for HB 892.
Thank you, Chair. We'll have a hearing HB 892 relating to law enforcement. First up, we have the State Department of Transportation in support.
Yes, sir. Mr. Chairman, first of all, I would like to thank you for having giving this very worthy piece of legislation a hearing. And I'd also like to thank Chair Raybook and the members of the Law Enforcement Standard Board. I'd like to thank the Attorney General. I think we're moving in the right direction. Our concern is that the funding level is not sufficient. We believe that something is important at this, as we're coming out the gate, we need to have a robust move. And then, the funding level is bounced around a little bit. We're now asking for something less than $500,000, which I still think is a little bit thin. But thank you, sir. I appreciate it. We'll stand on our testimony. Mahalo.
Okay, thank you. Next up, we have Department of Taxation in support. Department of Taxation, are you there? Okay, seeing none, Department of the Attorney General in support.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, committee members. Lance Goto for the Department of the Attorney General, which supports this bill. The Law Enforcement Standards Board was established in 2018 by Section 139-2 Hawaii by statutes. It's responsible for establishing minimum standards for employment as law enforcement officers and certifying persons qualified as law enforcement officers and enforcing these certification requirements on the officers. The tasks for the board are quite substantial, quite significant. This bill will help the board with the funding, staff, resources it needs to comply with its statutory obligations. It also needs an extension of time of the deadline to complete its tasks from beyond the December 31st, 2021 date. This bill from 2021, this is a 2021 bill, extends the deadline to June 30th, 2023. But as indicated in the board's report to the legislature submitted for this session, the board is requesting the deadline be extended to June 30th, 2024. So the department does respectfully request that this bill be passed to help the board achieve its substantial task. Thank you.
Thank you. Next up, we have the LNR in support.
Thank you. Jason Redula on behalf of Chair Case, the LNR. The department will stand on its written testimony in support. Thank you.
Okay, thank you. Next up, we have the Law Enforcement Standards Board in support.
Aloha, good afternoon. I'm Todd Raybuck, Chief of the Kauai Police Department, and today I'm representing the Law Enforcement Standards Board as the board's chair. Thank you all for allowing me the opportunity to testify today. I won't repeat some of the testimony that's already been provided. I have submitted written testimony on behalf of the Law Enforcement Standards Board in support of House Bill 892, and in consideration of available time, I'll keep my comments brief. As was mentioned, the Law Enforcement Standards Board was tasked with some very critical areas of establishing standards for our law enforcement throughout the state. The legislature put these standards in place and with a broad range of law enforcement entities throughout the state. We are the only law enforcement, we're the only state without a standards board, and it is important and necessary for us to be able to carry out this mission that's been placed upon us via Act 220. Other states that have enacted these types of boards have done so incrementally over long periods of time. For example, Oregon took them approximately 15 years to fully go from just establishing standards for law enforcement officers to including other areas of the state, such as Department of Taxation, Corrections, and otherwise. And so this is the fourth consecutive session the board has a bill before the legislature requesting funding and additional time to carry out the duties placed upon the board. I'd like to thank you, Chair, and the other members of this committee that have supported the board's previous bill requests. As outlined on pages 1 and 2 of my written testimony for House Bill 892, we're requesting amendments to Section 139.2, as well as the funding that was previously mentioned for the board to hire much needed staff and carry out its obligations. The board is committed to accomplishing its mission. The amendments requested and the approval of this bill will have a direct positive effect on the board's ability to execute its responsibilities. On behalf of the Law Enforcement Standards Board, thank you for your careful consideration for House Bill 892.
Okay, thank you. We also have the Department of Public Safety and the County of Hawaii Police Department submitting comments, DPS with comments, Police Department of County of Hawaii in support, and one more individual in support. That's all the testifiers we have here those today. Members, any questions?
Chair, I have a question.
Yep, Rep. Ward.
Thank you. Chief Raybuck, excuse my ignorance, but what does the board feel like what it's done and is most proud of? I'm not that familiar with the board, but I'm a little bit confused about, it was kind of like the choosing of the officer, not to do with the behavior of the officer. And, you know, we've had a number of things that the media's covered where, you know, so-and-so got shot and they shouldn't have done it. Do you guys deal with the behavior or just the qualifications of becoming an officer? or am I coming from square one? I don't really know what the standards boards are, because whether they're behavioral or they're characteristics of employment.
Representative Ward, thank you for the opportunity to answer your question. First, the duties of the Law Enforcement Standards Board does, first and foremost, is required to establish certification standards for law enforcement officers throughout the state.
That's
Secondly,
training, right? That's for training purposes. Okay, the individual officers. Thank you.
Sir.
And then?
Secondly, I'm sorry, sir.
No, please proceed. I sorry to interrupt you.
No, that's okay. Secondly, the board is tasked also with identifying a decertification process for police officers that do not meet the standards. That decertification process may include removing the state certification of an officer who's engaged in activities that the board may establish as criteria for removing that individual's capacity as a law enforcement officer in the state.
Is that a disciplinary thing, or you've said something about decertify? Why would you certify somebody if they're not qualified to begin with? Or are you talking about future behavioral issues?
So the certification process would be the initial granting of certification for that officer to carry out the duties of a law enforcement officer in the state. Subsequently, after certification, of course, this is all preliminary information that the board still has to identify, resolve, and adopt. But based upon acts committed after the certification process, the board was also tasked with identifying a decertification process, which in theory is not a disciplinary matter. That discipline belongs before the counties or entities, law enforcement entities themselves. This would take into consideration the acts of the law enforcement officer and then decertifying them as a member of the police officer or as a member of law enforcement in the state.
Thank you, Chief. I'll go back to my first question. What do you feel that you've accomplished or you're most proud of having a decertification and a certification board?
Well, we haven't been able to accomplish that yet. What I think we are most proud of as a board is that without any staffing or funds, we have started to begin the process of establishing our rules, as well as we've reached out to approximately 17 different state peace officer standards boards to receive information and look at templates that would be viable for us to consider here in Hawaii.
Okay, so this will just give you some money and some credibility to get off the ground, so to speak, which you have not been able to so far.
That's correct, sir. We have 9 ex officio members. Those members are all non-paid part-time members. The funding in this bill would allow the board to hire a full-time staff, an executive director and clerical staff, to carry out the directions of the board to actually make progress and what we believe and hope to implement the certification and decertification process as outlined in our House Bill 892.
Thank you, Chief, for your testifying and for your service. Thank you, Chair.
Thank you, sir.
Thank you. Members, any other questions?
Yeah, I do have a question.
Yes, Chair.
Chief Raybach, I'm wondering, the bill specifies $292,500 for the budget. Department of Transportation has suggested that that's insufficient. Any comments?
Thank you, Chair. Yes, our original bill that was submitted last year in the last legislative session did request $292,000. That was a pared down request from the board's decision to request $483,000 and I think $500 last year. The board decided or determined that based upon the financial status of the state due to the COVID pandemic, we pared down our original financial request, appropriations request, in consideration of the burden, financial burden facing the state. Given the fortunate turn of events and the funding that appears to be more available this year, we went back to increasing, as you'll see in my amendments in my written testimony, requesting $483,500 to be able to fully implement what the board has decided is necessary to hire an executive director, clerical staff, and the associated costs.
Okay, thank you very much.
Thank you, members. Any further questions? If not, we'll move on to HB 893 relating to law enforcement vehicles. We have first up the Department of the Attorney General in support.
Good afternoon, Chair, Vice Chair. Let's go to for the department, which supports this bill also. The purpose of this bill is to authorize the department to operate motor vehicles equipped with, well, it's our department investigations division, our law enforcement unit, to equip them with blue colored or blue and red colored lights, which is consistent with the law enforcement function and ensures the public recognizes their vehicles as emergency law enforcement vehicles. They currently do not have that authority under section 291-3.5. This would provide them that vehicle capability similar to that which is already been granted to the county police departments, public safety, land and natural resources, transportation, harbors division. And we feel that this is important. We would note that going back to when 291-3.5 was originally adopted in 1985, we looked at the conference committee report for that. It was House Bill 830 that passed at that time. And the committee in its report noted the legislative intent regarding this law. It said the committee is concerned about the increase in the incidence of police impersonators and believes that it is important to be able to prosecute persons who operate vehicles set up to resemble police vehicles or that at night could be mistaken for police vehicles, but who are not in the act of who are not in this act of impersonating a police officer. So the concern was impersonation of law enforcement. And that was why this law was passed, to try to prohibit others other than law enforcement.
Lance, that's been 2 minutes. Can you summarize and conclude your testimony?
That's it. We'd appreciate the committee passing this bill. Thank you very much.
Okay, thank you. We also have 2 individuals, one in support and one in opposition to this measure. Members, any questions? Okay, if not, I've got a question for Lance.
I'll follow that also, please. Thank you.
Okay, no, go ahead, report.
Well, I was going to say, is it that they don't get the respect and they want to run red lights from the AG's office, or was it the last statement that the AG made, and this is for the AG's office? You said impersonation. How many people want to go out and impersonate the AG? That sounds a bit odd. What's the experience rating?
No, the original law was passed when the legislature was concerned about people impersonating law enforcement officers using blue lights. Back in, I think, around 1982 was when there was the Lisa Au murder. And they believed, the investigators believed that she was stopped by someone impersonating a law enforcement officer using blue lights. Back then, people were using blue lights and attempting to stop other people on the roads. So this law was passed to prohibit people from using blue lights on their vehicles and trying to restrict it only to law enforcement use.
But why does the AG need blue lights is the question. I mean, you guys want to run red lights, or you're not getting respect, or people are they want to grow up and be an AG impersonator? I don't get it.
No, the investigators for the department are law enforcement officers and have that and are full law enforcement authority, participate in all different types of law enforcement investigations and in emergency situations, and may need to respond to different types of crime incidents as well as emergency incidents.
Could you give an example, Mr. Goto, about when this would be the most practical and applicable? In other words, not having a blue light would be something that would be not advantageous. When do you need a blue light? What's an example?
When they may need to respond in times of emergency.
Example.
Well, I mean, if
you're talking about the AG, right? You're not talking about a policeman. You're not talking about a fireman or an EMS. You're talking about the AG responding to an emergency who needs a blue light. What's an example of that utilization?
They participate in all different types of law enforcement functions in emergency situations where they may need to conduct traffic control, control crime scenes.
Okay, I'm not sure I understand the example. So when there's a homicide or there's an accident on the road, the AG is going to be called out. I don't, maybe I'm missing something in law enforcement. I thought the AG was like interpretation of the law and something a little less passive than first responders. It sounds like the AGs are first responders given this bill.
They are, and they do act. Our investigators are full law enforcement officers and do engage on occasion in first responder capacities. They do respond to crime scenes and engage in criminal investigations, as well as assisting in other types of emergencies, civil emergencies as well.
Without the blue or the red lights, they're not going to be given the access or the respect or the responsibilities. The impression I'm given, I'm not sure that that's the case, but that's the impression.
No, but it's easier for the public to recognize them in their law enforcement capacity.
For the purpose of what?
Just driving up in a unmarked vehicle. The general public and other people may not recognize them as law enforcement.
And the purpose for them to be recognized as law enforcement is what?
So they can conduct their business, their law enforcement business, and be recognized as such, and that they can get cooperation from the general public in that manner.
You don't have a uniform. You're just talking about the car, right? You're not talking about something that says there's a investigative AG uniform. So when somebody gets out of the car, if they don't see the car, they're going to see this person, and they won't know that they're a law enforcement officer. Is that the case?
No, they may be in uniform also.
Okay, I think that's as far as I can go. Thank you very much, Mr. Cotto. Thank you, Chair and Vice Chair.
Yeah, any other questions? If not, I've got a couple. Lance, don't AGs carry badges?
The investigators have badges.
Okay, so they can use their badge to identify themselves in an emergency situation, is that right?
Yes.
Okay, and I mean, and speaking as an attorney here, if I got into an accident and I needed a first responder and an attorney shows up instead, like one of your AGs, I'm going to think that I'm in even more trouble than normal. I just can't. I mean, look, I honestly cannot. And it seems like you're having trouble thinking of an example as well. But I honestly cannot think of a situation where we need cars to move out of the way so that the AG can get there quickly. I mean, in fact, in the AG's haste to get there, they may be creating a traffic problem for a police officer or an ambulance to get to the same scene because they're altering the traffic pattern and people are stopping and moving out of the way. So I just cannot, I mean, if you can give me a concrete example right now, I would really appreciate it, of an example where an AG needs to be at a crime scene or something so urgently that they need emergency powers granted to them by those blue lights. But if not, then I think this bill has to be put to rest.
Well, I'm not talking about attorneys. we're not talking about attorneys. We're talking about the investigators.
Investigator. Okay,
or
so
the
when is the
agents.
situation where the
investigator
investigator needs to get there so urgently that we need to alter traffic in order for them to get there?
Well, it's not just a emergency and like a traffic kind of situation. It's participating in different types of
If it's not just traffic, can you just paint Attorney General on the side of the car and put the Attorney General seal on it though? I mean, if it's recognizing the car, there are other ways to do that without giving emergency responder power. I mean, there's a reason we need ambulance and police to get to situations immediately, and I think everyone recognizes that. I cannot think of a reason why investigators at the AG's office need to do the same.
Well, they're full law enforcement officers.
Right.
And they conduct criminal investigations just like the police.
Does the 911 dispatch contact the AG's office for their investigators under any situation?
No, but
Okay.
the investigators do respond to crime scenes.
Yeah, and they should.
They may also in certain when they're engaged in investigations, there may be instances where they do need to stop vehicles, stop people, make arrests. So this will help in their operations when they're conducting these types of criminal operations, for people to recognize them when they need to be recognized as law enforcement on the road. They can turn on their lights. People will recognize them as such. If they are in unmarked vehicles, or even if they're in marked vehicles that have on the side of the vehicle,
how many arrests have they made in the last year?
I can get that kind of numbers for you. I don't have that offhand.
Okay, that is the kind of information. I mean, if you're asking for these powers, that is the kind of information that we expect to have. I mean, that would be proof, right? That you need. I mean, how many times an AG would have liked to pull someone over to arrest them but could not, I think is relevant. So if you can get that to us, I'd appreciate it.
Yeah, I can follow up. There's also, well, I will follow up and provide you more information on that. It's not just in arrest situations. It's also in time. They need this kind of recognition. Emergencies.
Okay, I think we're taking a little too much time here, Lance. If you could just expand on the reasons that Rep Ward and I brought up and email our office, I'd appreciate it.
Will do.
Okay, thank you.
Thank you.
Okay, moving on to HB 2075 relating to firearms. We have a number of testifiers for this bill. First up, AG's office in support.
And good afternoon, Chair Nakashima and members of the committee. Deputy Attorney General Amy Murakami. The department supports this bill. The purpose of this bill is to address a recent federal court ruling in Yukatake versus Connors, which declared that two provisions of Hawaii's firearms statutes were unconstitutional. The first was the section that required a firearm permit for a handgun to be used within 10 days of its issuance. And the second is the section that requires all firearms that are not being registered by a licensed firearms dealer had to be physically inspected at the time of registration. This bill is necessary to protect the safety of the public. And if this bill is not enacted, permits to acquire will never expire and no firearms will be examined by law enforcement to ensure that they match the registration information and they comply with Hawaii law. The permit to acquire contains a lot of background information that can change over time, specifically regarding a person's qualifications to own a firearm, such as criminal convictions, mental health diagnosis, and being the subject of restraining orders. For this reason, there needs to be an expiration on the permit, and 30 days is long enough to give a person enough time to use their permit to acquire. As to the physical inspection of firearms, this bill carves out 3 categories of firearms that would require physical inspection and registration. It will not affect firearms being purchased from a licensed firearm dealer and sold to a person. Those firearms will continue to be registered without being physically inspected. What this bill does is for 3 categories of.
Thank you, Amy. That's been 2 minutes. If you could conclude your testimony and summarize.
Thank you. We asked the committee to pass this bill in order to protect the safety of the public. Thank you.
Okay, thank you. Next up is Honolulu PD in support.
Good afternoon, Chair Nakashima and Vice Chair Matayoshi and members of the committee. I'm Major J. Trinidad of the Honolulu Police Department, and we stand by submitted written testimony and open up any questions at this time.
Okay, thank you. Next up, we have the DC project in opposition. Oh, you're still muted.
I'm sorry, I'm confused. Is that me?
Yep, that's you.
Okay, I'm sorry. I just would stand on my written testimony and just emphasize that this bill would be unconstitutional. It was already ruled unconstitutional. To reinstate it would be unhelpful and unlawful. And I don't believe that it would protect the safety of the public. Thank you.
Okay, thank you. Next up, we have the Pu'uloa Rifle and Pistol Club in opposition.
Aloha, I'm Jerry Ewan representing the Pu'uloa Rifle and Pistol Club. Excuse me. This bill, again, like Soleil said, is unconstitutional.
Jerry, let me interrupt you. Are you driving right now? Are you operating the vehicle?
I'm parked.
Okay, please proceed.
Okay, once again, unconstitutional. It will do nothing for public safety. It actually hinders people from coming to my club and actually competing because all our competitors from out of state have decided not to come to Hawaii. It just means they're going to have to stand in line and they probably won't get a chance to register it here. I was former military. A lot of people, they come to Hawaii with their guns. They find out they have to stand in a long line. They're not going to register them. So once again, I'm in opposition to this. And pretty much that concludes it along with my testimony.
Okay, thank you. Next up, we have the Hawaii Firearms Coalition in opposition.
Hello, my name is John Abbott. Can you hear me clearly?
Yes, please proceed.
Okay, great. John Abbott, Hawaii Firearms Coalition. We are opposed to this legislation. The ruling in Yukutake versus Connors was very clear that any inspection of firearms was to be deemed unconstitutional. That included firearms brought in from out of state, as well as homemade firearms. It didn't give any carve-outs for what type of inspections were okay. They were all categorically unconstitutional. And this is again a sad attempt to re-implement something that is not needed. During the case, the state did not prove any reason that inspections actually improve public safety. In fact, there's a lot of evidence that when the firearms are inspected, it turns out that the HPD or whichever department was measuring the quote unquote firearm did not measure it correctly. So we stand on our written testimony, and if this legislation is passed into law, it will result in further legal action, and that would cost the state another couple $100,000 in unneeded expenses. Thank you.
Thank you. Next up, we have Marcus Tanaka, an individual, and these are all going to be individuals going forward. Marcus Tanaka in opposition. You're muted, Marcus.
There we go. We good?
Yeah,
okay, hello?
Proceed.
Okay. Just want to I support my written testimony, but I just wanted to give an example. So someone say they live in Pro City but works in town. Okay. by them having to physically bring the firearm to the police station, that means they got to go back home to Pro City first, because most employers don't allow firearms in the workplace, and they cannot leave their firearm in the trunk of the car because, one, that's just irresponsible, but it's also against the law. So which means, again, they got to drive back to Pro City. Okay, then grab their firearm at home, drive back to town to the HPD main station, wait in line, register it. And if, say, they're doing this on a break or midday, then they got to, again, they can't bring their firearm back to work or leave it in the car. So then they got to drive back home to Pro City, drop off their gun, drive back to their work. Okay, that's if they get more than a 1 hour lunch break. Now, say someone wants to do this after work on a Wednesday, because HPD is open till 6:30 on Wednesdays only. Get off work at 5:30. I have 1 hour to drive back to Pro City in going home traffic to grab my firearm and make it back to HPD in town. That might be cutting it kind of short. And then, I'm hungry after work, so I want to go get something to eat. I can't bring my firearm with me to go to the supermarket or buy takeout because that's against Hawaii law. And again, I can't leave it in the car either because that's just irresponsible, but that's also illegal too. So which means I got to drop the firearm back off at home in Pro City and then come back out and find somewhere to eat. So that's just one example of what implementing something like this again will do, instead of me just taking 5 minutes to go online, put in all the information and hit submit or send or enter, whichever button it is, So I stand by my written. Thank you.
Okay, thank you. Next up, we have Michael Rice in opposition.
Hello, aloha, Michael Rice again. I'd just like to reiterate my opposition to the bill. I will mention an incident that took place involving my brother, where he was actually assaulted by a homeless individual while he was standing in line to register his handgun at HPD. The incident happened very quickly, and nobody in line and no police officers nearby even noticed it. I actually got from the parking garage where I was up to him before HPD even responded to him and asked if he wanted to press charges against the man who hit him. And unfortunately, he declined to press charges. But this just shows that it's not safe to be having guns, because all somebody has to do if they want to get a gun, hey, is $100. Anytime you see somebody with one of these cases or a long suitcase, go grab it, run, come to me, I'll give you $100. That's how easy it would be for criminals to get a hold of guns here. That it exposes them to theft, not to mention all the other things like how I would have to live in Makaha. I would have to go straight to HPD, straight back with my gun. I can't even stop at McDonald's to pick up something to eat. I'd also like to expand on something that Jerry said. Most people, when most of the provisions for these registrations is what they refer to as ghost guns, which is self-manufactured firearms, out-of-state registration, and person-to-person sales, which all already require police notification. Now, two of those, if the person is willing to step forward and register their firearm, they're not likely going to be lying on the application, say, "Oh yes, this isn't a pistol. This is a Remington hunting rifle," instead of something that's illegal by state law. One of the so-called assault
pistols. That's 2 minutes. If you could
All right.
summarize your testimony, please.
Right. Well, that's about it. I've started my testimony. Thank you all. Any questions I'm able to answer, I'll answer.
Okay, thank you. Next up, we have Clayton Hubo in support. Okay, not present. Next up, we have Andrew Roberts, an individual in opposition.
Good morning, Chair, committee members. My name is Andrew Namiki Roberts. I'm a gun owner here in Hawaii. To begin my testimony, I just want to point out something that the Attorney General actually said. In-person registration and inspection of firearms was ruled unconstitutional. Now, this isn't something where the legislators changed the law. This is a judge has made a declaration that it's unconstitutional, and the Attorney General just told you that. So therefore, to re-implement the law back to its previous status, even if it's in a more narrow term, is still unconstitutional. And the Attorney General has appealed this case. This case is on appeal at the 9th Circuit, and a 9th Circuit judge will make a decision on this case later this year. So this law isn't needed if the Attorney General is correct that this law has a purpose and it protects public safety. Surely a Ninth Circuit panel will declare this and the law will be re-implemented without going around a judge's orders. The other thing that I want to point out is this is a claim of safety, that guns are coming into the state and that they could be illegal or not within Hawaii law. Well, we've looked at the numbers. Between 2012 and 2021, Hawaii registered 371,409. That's a very minuscule amount. And if a firearm is illegal, it's slightly undersized, or it's not allowed here, wouldn't you rather have it registered? Even if it is illegal, at least that way, if it turns up in a crime, we know who owned it. By eliminating the in-process,
summarize your testimony.
The Attorney General knows that this is unconstitutional. The judge has declared it, and the Ninth Circuit will make the decision on what's going to happen. Therefore, this bill should be deferred.
Thank you, and I apologize. I'm going to butcher a couple names here. Ryan Tinajero in opposition.
Here, sir. Representatives, thank you for your time. I stand on my written testimony. I also want to point out that I find it quite contradictory that the state of Hawaii strives to enforce federal law when it incorporates restrictive federal firearm regulations within its firearms permit scheme, while at the same time failing to comply with a federal court order that grant enhanced Second Amendment liberties to the people of Hawaii. It's time to actually represent the fundamental civil liberties of your constituents. You can do this by complying with the court order issued by the Hawaii District Federal Court, specifically extending the pistol and revolver permit acquisition timeline. This is the only valid move for you. In-person inspections, as repeatedly stated by my counterparts earlier, have already failed constitutional muster. Again, I find this legislature's non-compliance to a federal court order to be non-representative of the people that it is supposed to serve. Thank you for your time, and I'm available to answer any questions.
Thank you. Next up, we have Jacob Holcomb in opposition. Not present. Next up, Todd Yukutake in opposition.
Good afternoon, Judiciary and Hawaiian Affairs Committee. I, Todd Yukutake, I'm the plaintiff in this lawsuit of Yukutake versus Connors, and I oppose HB 2075. I was the plaintiff in this lawsuit, and we won the lawsuit in federal district court, and this bill violates Judge Seabright's order. Just to make it clear, I do not want in-person inspection of any firearms, but however, I do support the 30-day permit expiration date change. This bill serves no purpose as a burden to me. Judge Seabright rejected the state's arguments, and no other state in the nation has an in-person firearms inspection requirement. If this was useful for public safety, other states would have something like this by now. It's nothing new, basically. It costs me time and money to register my guns in person. Just like in my testimony, I write the 5 steps needed for me to register a firearm: go to work, go to my residence to pick up a firearm, go to HPD, register it in town, go back to my residence, drop it off, and return to work. All of that cost me $300 because I have to take the entire day off to do so. And so far up to this point, I registered 6 firearms that were either purchased on the mainland or done through private sales. So basically, under the rules of this law, I would lose $1,800 in wages if this bill were to continue, and from my past purchases. Police departments have already implemented remote firearms registration through the internet, email, or phone. They don't have to go down to a police department. They just do it on the phone or internet at home. They don't have to take a day off of work. Everyone loves this program, so don't mess up a good thing. People can voluntarily go to the police department to get their firearms inspected.
So you could talk, that's been 2 minutes. If you could conclude your testimony.
Okay, yeah, there's already a process in place. People can do it voluntarily to get their firearms inspected.
Good afternoon, Chair Nakashima, Vice Chair Matayoshi, and members of the committee. My name is Alan Komogomi. I'm a Deputy Public Defender, and I'm testifying in opposition to this bill on behalf of the Office of the Public Defender. This bill seeks to make several changes to our existing laws of negligent homicide. First, it aims to rename our negligent homicide statute to vehicular homicide. And by doing so, it seeks to elevate all penalties across the board for negligent homicide, first, second.
Present. Any questions? Hearing none, we'll move on to HB 1866 relating to intoxication. First up, we have the Office of the Public Defender in opposition.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Ben Lowenthal. I am a public defender assigned to Maui. And the Public Defender's Office is in opposition to this bill for a very specific, and forgive me, kind of technical reason. The objection is the codification of Birchfield versus North Dakota. Bottom line, so what we're saying is that this bill would authorize the police to compel any person, whether they're arrested or not, of a breath test, which goes beyond Birchfield versus North Dakota. It goes beyond the Fourth Amendment exception, because that exception requires an arrest. So that's one problem. The second problem, which in my view is the more significant problem, is that this bill gets ahead of any interpretation the Hawaii Supreme Court has had of Article 1, Section 7. It will invite a challenge and would cast a cloud over any other convictions that are happening before the Supreme Court gets to resolve that issue. So I do note, and we do note, that it is commendable to try to keep this within the restrictions of what is constitutionally permissible by having search warrants. But we believe, the Office of the Public Defender believes, that making this distinction between the breath and the blood test is getting ahead of where our current constitutional law in Hawaii is right now. So for that reason, we ask that we oppose the bill and ask that that provision regarding breath tests be stricken. Thank you, and I'm available for any questions.
Okay, thank you. Next up, Department of Transportation in support.
Well, Chair, standing on testimony support. Thank you.
Okay, thank you. We've got another Mothers Against Drunk Drivers in support and 4 other individuals in support, but none are present. Members, any questions? Okay, if not, I have one question for the Public Defender's Office. In your testimony, you indicated that breathalyzers could be compelled if the individual is arrested. Is that correct? Did I read that right?
Yes, under the Fourth Amendment. And so and as you have Fourth Amendment, which is the federal law, and then you also have the state constitution, which is a different story altogether. And so I guess sorry, I wasn't so clear on it, but under the Fourth Amendment, there is the exception search incident to arrest.
Right.
But what we don't know is what the Hawaii Supreme Court will do in interpreting our Hawaii provision. Thank you.
So you're saying that Article 1, Section 7, I think, of the Constitution might still be violated if the person is under arrest and compelled to take a breathalyzer test?
Correct. And the reason why is you have that Wilson case by the ICA. It's written by former Chief Judge Craig Nakamura, who pointed out that our search incident to arrest exception is very different than the Fourth Amendment's.
Okay. Is the Supreme Court scheduled to hear and resolve that issue anytime soon?
I am not aware of any. And one of the reasons why we oppose the bill is because this would squarely put this in front of a court at some point if there is a compelled breath test without consent or without a warrant.
Okay. When the ICA made its determination, did they say that it was so different that they cannot? Or did they just point out that there was a difference between the Fourth Amendment federally and Article 1, Section 7?
What the ICA did was they were extremely reluctant, as they should, they're the ICA, to get ahead of the Supreme Court. What they pointed out was that the Supreme Court standard for search incident to arrest is very different than the Fourth Amendment's, and it kind of speculated in a weird way, which you don't really see often in the ICA, saying if the Supreme Court were to agree with essentially the Fourth law that was made here in Hawaii about Hawaii's exception, and that's as far as they went.
So it's dicta, it's not a holding or anything like that?
Correct.
Okay, thank you. Members, any other questions?
Chair, I have a question.
Go ahead, report.
HPD, if you're there. In the instance of DUI cases, this is applicable only to collisions. In your understanding of DUI cases, how many of those involve collisions versus just generically dodging and weaving or whatever when you find somebody driving? Are you there, HPD? Oh, there you are.
Sorry, Representative Ward, we did not submit written testimony for this bill. All the DUI cases that we get or the impaired driving cases that we get. I mean, I think we had somewhere in the ballpark of 5,000 last year. Wait, I'm sorry. I'll get you the numbers. I can actually get that for you in seconds.
5,000 DUIs, non-collision.
I'll get you that number, sir.
And Rep Ward, just to be clear, only Office of the Public Defender and Department of Transportation submitted testimony who are here.
Okay.
Thank you to HPD.
Okay.
Chair, were you going to pass the question to them? Is that what?
No, I'm just saying thank you to HPD for stepping in, but HPD can answer if they'd like.
Yeah.
Sorry about that. Okay, I thought you were waving me
Captain,
off.
don't go away, Captain.
My fault.
Not a problem. Okay.
So you got the numbers? Total
Getting it,
DUIs versus the number of collisions DUIs. The point is, you said that the majority of them are non-collisions, right?
Yes, a great majority are non-collision. There we go. Total OVII. Last year we had over 2,500 DUI arrests. The 5,000 was the 2-year combined. So we have about 2,500. In 2019, we had 3,600 DUI arrests on the island.
Captain, of those, how many, if this bill passed, would be subject to this DUI test, mandatory?
Let's see. Well, I mean, for that, we wouldn't, I mean, it would come down to basically reading the 18
statutes. Thank you for the opportunity to testify in favor of this bill. It's known as our statute revision bill, which we prepare as part of our statutory duties with respect to revision functions. It contains mostly technical amendments. They're not intended to be substantive, or if they are to correct errors, omissions, or obsolete law. All of that is explained in the memorandum that is attached to the testimony. And I'd like to note that we have the Attorney General review this bill prior to submission, and we have made any changes that they felt were necessary. So I'd be happy to answer any questions, and we'd also be happy to assist you with the committee report and any changes the committee deems necessary. Thank you.
Yeah, thank you. Next up, we have Tax Foundation with comments. And Tom is not here. So members, any questions? Seeing none, let's move on to HB 2074 relating to credit for time of detention prior to sentence. First up, we have the AG's office in support.
Good afternoon, Vice Chair Mariyoshi. Lance Goto for the Department of the Attorney General. We strongly support this bill. The purpose of this bill is to amend Section 706-671, subsection 3, to clarify that a defendant being sentenced for an offense that was committed while serving a sentence of imprisonment on a separate, unrelated felony conviction cannot be given credit for a period.
Is denied that credit time. And so a person has to choose between exercising their right to trial versus their right to get credit, which they should get anyway. Lastly, the way the bill is written, it says that any periods of detention, and that would include pre-trial, pre-sentence, and post-sentence detention time, shall not be deducted from the minimum and maximum terms of the sentence imposed of the later crime. And so basically you're saying that the person never gets any credit. So I think perhaps it doesn't serve the purpose that the AGs would like it to serve or demonstrates any legislative intent. What it does do is create a de facto consecutive sentencing scheme for this type of defendant. And for those reasons, we oppose it. And I'm open to any questions. Thank you.
Okay, thank you. We have the Department of Public Safety and the Prosecutor's Office both in support, but not present today. Members, any questions? So, Mark, you want to speak on this?
No, Chair, just that we are present and stand on our written testimony.
Okay,
thank you.
Thank you. Members, any questions? Seeing none, I have a question for Mr. Bento, and caveat, I mean, I'm not a criminal attorney, but I understood that sentences can sometimes be served concurrently or not concurrently at the discretion of the judge. Are you saying that that should not be the discretion of the judge, that they must always be served concurrently?
No, what I'm saying is that the way that the bill is written currently, you would take away that discretion from the court. You are correct that a judge could sentence someone to concurrent time or to consecutive time. But because the bill is written in a way that takes away that detention credit and says, it says any periods of detention, and that means that any periods of detention would be pretrial, pre-sentence, or post-sentence. That means that the person never gets credit for that time until their first sentence is served, and that would mean a de facto consecutive sentence. That would be unintentional if the judge did not
But
wish
you're saying
to
that
the person.
you're saying that a judge can still order concurrent serving of sentences. Is that right?
The judge could order concurrent serving sentences.
And you have no problem with that.
I have no problem with that.
There's no
but this is-
constitutional issue.
No, the judge can have concurrent or consecutive sentence, but this is the problem. The case that's cited, which is State versus Thompson in my written testimony, it spoke to that particular issue because that gentleman was sentenced to concurrent time. His sentence was deemed illegal because he received an illegal extended term. He was then sentenced to consecutive time to correct that illegality. And then we ran into all of these different problems about the credit time that he deserved. That's why I encourage you to read that case and to ask questions of the AGs about how do you answer these questions of unconstitutionality dealing with the way this bill is currently written.
Well, AGs, are you on? You want to respond?
I'm sorry,
What Mr. Bento is bringing up constitutionality issues to this bill. I'd like the Attorney General's response.
I think Mr. Bento was arguing with double jeopardy.
Lance, you're kind of breaking up.
I'm sorry. I didn't understand Mr. Bento's unconstitutionality argument. I think he was arguing double jeopardy. Is that correct?
Well, there are two arguments, one being double jeopardy, and the second being that a person has to choose between exercising their right to a trial or pleading guilty early so that they can get their pre-sentence detention credit, both of which we argue is unconstitutional.
Well, this bill is not raising, I don't see it raising a double jeopardy issue. We're talking about pre-sentence detention.
Mr. Bento, isn't this only applicable if they're currently serving for another crime anyway, too? So this doesn't apply to someone who has only committed one crime and is serving a sentence prior to pleading. This person is already in prison. Am I correct?
That is correct.
Okay. Okay, thank you. Members, any further questions? Okay, hearing none, we'll move on to HB 2422. First up, we have Public Defender's Office in opposition.
Aloha, my name is Darcia Forrester from the Office of the Public Defender. Our concern is with the blind mandate in this bill and the assumption that all restraining order violations involve domestic violence. We do not think a blind mandate for domestic violence classes for nonviolent restraining orders or nonviolent violations is appropriate in every single case without exception. This bill would create a disenfranchised class of defendants and hamstrings a judge into ordering domestic violence classes, even when the issue the defendant is struggling with has nothing to do with domestic violence and may not be appropriate for the specific circumstances for that defendant. We strongly object to this mandate in light of the lack of support or resource services available to non-probation defendants who would be required to basically figure it out on your own without the support services of a probation office. Thank you. I'm available for questions if you have any.
Okay, thank you. Next up, we have the Honolulu Prosecutor's Office in support.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. Department stands in support of House Bill 2422. Purpose is to address a Supreme Court decision in State v. Adinoe. This bill is to clarify that bill. So we're stand in support and here for any questions. Thank you.
Okay, thank you. That's all the testifiers we have today, although we do have the Hawaii State Coalition Against Domestic Violence in support and another individual in support. Members, any questions? All right, seeing none, let's move on to HB 2197 relating to gambling. First up, we have Office of the Public Defender in opposition.
Hi, good afternoon, Chair, Vice Chair, members of the committee. I'm Assistant Public Defender Lee Hayakawa. The Office of the Public Defender respectfully opposes HB 2197. This measure would make promoting gambling in the first degree and second degree non-probationable, meaning that the courts will have no choice of sentencing a mandatory 10-year prison term for promoting gambling in the first degree and a mandatory 5-year prison term for promoting gambling in the second degree. This measure will result in sentences that are cruel, harsh, and excessive. HRS 706-620 provides a short list of offenses that are currently non-probationable, charges where the court must sentence the convicted defendant to the open term. It is a short list and includes the most serious and/or violent offenses such as murder in the first degree, murder in the second degree, and almost all Class A felonies, to name a few. Promoting gambling does not belong on this short list. Judges should retain the authority and discretion to impose probation where probation is appropriate. Thank you for the opportunity to comment on this measure.
Okay, thank you. Next up, we have the Honolulu Prosecutor's Office in support.
Thank you, Chair, Vice Chair, members of the committee, Deputy Prosecutor Trisha Nakamatsu appearing on behalf of the Honolulu Prosecuting Attorney's Department. We are in support of this bill, and I understand you have our testimony in front of you. We would note that given the seriousness of the types of incidents that have been seen around, as the bill points out, illegal gambling houses in particular, the types of activity that these establishments attract or generate, it's hard to tell which, is extremely serious. As we've all been seeing over the past years. We would note that with regards to the sentence for a Class C felony and a Class B felony, they are open terms. So individual offenders still go below before the paroling authority to get their actual minimum sentence, which they actually have to serve, and the rest would be ostensibly on parole. We're available for questions, if any. Thank you very much.
Okay, thank you. And lastly, we have a late individual testifying in support, Sylvia Penarosa. Okay, not present. Members, any questions? Okay, hearing none, moving on to HB 1179 relating to invasive species. First up, we have DHHL in support.
Yes, good afternoon, Vice Chair and Chair. The department stands on its comments, just highlighting that we support the intent of the measure as long as it doesn't impact the governor's budget request. Thank you.
Okay, thank you. Next up, we have Symbrosia Inc. in support. Nope, not present. All right, we have a number of testifiers in support, 10 in support, 1 with comments, but none other are present today. Members, any questions?
Chair, I have a question.
Yep, report.
Mr. Ayla, thank you for your testimony, and excuse my ignorance, what is the value of the crop and what is it comprised of? If it's in my paper here, it says gorse, G-O-R-S-E. Could you define that a bit?
Gorse is an invasive shrub that was introduced, I want to say about 60, 70 years ago. It's a problem in pastures in the area up at Humu'ula. The reference to value would be identifying products that could be made from gorse with the thought that if there was an economic use of gorse, there would be an incentive to go on the mountain and to remove it without expanding its current territory.
And that's the extent of the possible marketability or monetization of it. I mean, is it solid? Is it, you boil it, you drink it, you get energy from it? How much from square zero are we to make money out of gorse? Even though we're going to put something in statute, we should know a little bit more about it. At least I feel I should.
There are ongoing efforts to try to find a use for it. The University of Hawaii has looked at animal feed. Some pharmaceutical companies are looking at extracts, but there is nothing concrete at this time. So the motivation of this bill, I'm assuming, is to continue to examine possibilities, because the gorse is only going to become a bigger problem on our land and on other ranchers' lands on Mauna Kea.
Report, this is a 3-year pilot program as well.
Okay, but in terms of the cost for something that we have no really intuitive amount of insight is, to me, a little bit odd. I mean, why not halikoa or making money on seed pods from other trees? It just seems a little bit odd. Anyway, thank you very much, Mr. Ayala. Thank you.
Thank you. Members, any further questions? If not, we'll move on to HB 2028 relating to raw milk. First up, we have Department of Ag in opposition.
Good afternoon, Chair and members of the committee. My name is Leo Obaldo, Hawaii Department of Agriculture, testifying on behalf of Chairperson Phyllis Simabukoro-Geiser. The department stands on its written testimony in opposition. Thank you.
Okay, thank you. We also have Morris Atta from the Department of Agriculture. Morris, are you there? Okay, next up, State Department of Health in opposition.
Good afternoon, Chair Nakashima, Vice Chair Mariyoshi, members of the Committee of Judiciary and Hawaiian Affairs. We strongly oppose this bill. I did have my written testimony submitted. Sorry, I'm a little under the weather. But the main point of this bill is we do not need raw milk for our community. It's not a freedom bill. What happens if your child contracts some kind of communicable disease from raw milk, such as E. coli, listeriosis, or something else? He'll bring that into your schools and cause outbreaks elsewhere. So this is a serious public health problem. Every state that has relaxed laws on raw milk has shown an increase in hospitalizations and illnesses. Thank you for allowing me to testimony. Please, I urge you, please defer this bill. We do not need any more diseases in our hospitals. Thank you.
Okay, thank you. I also have Leo Obaldo from the Department of Agriculture. So 3 Department of Ag people here. Leo, did you have anything to add? Oh, I'm sorry, that was you.
No,
okay.
same.
But you were
Thank
stepping in for Chairman for Phyllis, right? Too. Okay.
Thank you.
Next up, we have Weston A. Price Foundation in support.
Hi, this is Pete Kennedy. I'm an attorney with Weston Price. I've worked on raw milk legislation in a number of states around the country. And at this time, there are 38 states that allow the sale or distribution for human consumption. There are another 6 states that allow the sale of raw milk for pet consumption. And there's actually a peer review paper that came out a few years ago that said as raw milk consumption has increased in the country, and more and more states have either expanded legal access or legalized sales, the number of illnesses has actually gone down. So it's a safe food. There are a number of legal foods that cause more illnesses than raw milk. For instance, romaine lettuce is one food that comes to mind. Hawaii is definitely an outlier when it comes to raw milk laws. I know there's fairly substantial demand for the product on good demand for the product there. And in Hawaii, like every other state in the country, it's legal to consume raw milk, but you just have a situation where there are people have this legal right, and unless they have the land and resources to have their own, don't have any regulation on it, and they've had a very good.
Okay, thank you. Next up, we have the Hawaii Food Industry Association in opposition.
Okay.
Nope, not there. All right, we've got a number of testifiers, individuals, mostly in support, a couple in opposition. Members, any questions?
Chair?
Yep, go ahead, Rep. Ward.
Thank you.
Hey, hello, Representative Ward.
Thank you for being the Chief of Police of Food Protection. You do a great job. I know you, but from a policy point of view, when we hear your testimony.
Good afternoon, Chair Nakashima, Vice Chair. Excuse me, members of the committee. Vice Chair Matayoshi, members of the committee. My name is Lauren Kim. I'm the Acting State Registrar and Policy Director for the Department of Health and strong support for this measure. I want to briefly highlight and the issue and an option for this committee. This amends Act 211, Session Laws of Hawaii 2021, which authorize non-religious and non-judicial licenses to perform marriage. By that, I mean the person who says, do you take this person to be your lawful witness, so-and-so. That was in itself a reaction to a lawsuit from an individual who was neither a judge nor belonged to
2018, January of 2018, 10 individuals drowned within a 2-week period on Maui. That prompted the Drowning and Aquatic Injury Prevention Advisory Committee to host a workshop in 2018 and also in 2020 to talk about snorkeling safety. I was on the agenda. I gave presentations at both workshops, but basically I'm here to tell you that the study conducted by Hawaiian Lifeguard Association was inconclusive due to insufficient data. Basically, that's what although there's a lot of theories and possible contributing causes to drownings, it was inconclusive. So basically, we need more data, and that's what this bill is. Conclusion, I just want to say that in order for the Department of Health to manage this data, they will need, and that figure should come from Department of Health. The other thing is snorkel masks should be preserved as evidence, as is kept as evidence in motor vehicle fatalities.
Shifted, and because of these masks.
That's a very good question. So just barely outnumber Pu'ukeka'a, which is in fronting Sheraton Kanapali on Maui. But per capita, by the number of people who visit each area, Pu'ukeka'a is number 1 and Hanama Bay is number 2.
Andrew, is that what other? That was not the case. Okay.
No, he was at Chang's Beach in Maui.
Okay. Thank you. Thank you very much. Thank you, Chair.
All right, seeing none, we'll move on to our last bill of the day, HB 1991, relating to consumer protection. Got 3 individuals testifying. Mr. Spiker, that is your time, but did you have anything else to add on behalf of Hawaii Silver Company? I noticed you're on this list twice.
I guess so. I'm finished, but my father, who's unable to be here, John Spiker, because of an illness and a disability now.
Yeah, please do so.
So thank you. My name is, this is on behalf of John Spiker, the owner of Hawaii Gold and Silver Company. He's been in business for over 43 years. He's been the president of the Hawaii Pawnbrokers Association for the past 20 years. He was HB, this bill 1991. First off, many pawn shops already electronically file their transactions and do so for their own reasons.
Prior to any further action
by this legislature. It can craft a bill that, unlike HR 191, bill rather than theoretical problems. The overreaching
Okay,
problem
thank you,
with
Dan. That's been 2 minutes. Can you conclude your testimony, please?
sure. It's
also have your
illegal.
written statement.
It's illegal for pawn shops or anybody to buy an unregistered bicycle. HRS 249-14.6. Why this duplication is even before us, I don't understand.
Reconvening the Committee on Judiciary and Hawaiian Affairs. We are in decision making. First bill, HB 1208, real property taxation. There are technical amendments by HMSO that suggested a rewording of the question. Shall the Hawaii Constitution be amended to repeal the county's exclusive right to exercise functions, powers, duties related to taxation of real property, thereby authorizing the state and counties to both exercise functions, duties, powers, duties, and relating to the taxing of real property. This bill already contains a defective date, and also the bill's author has asked us to put in an explanation on the purpose of the bill with the intention to eliminate personal and business income taxes to offset the property tax. Bill is already defect dated. Members, any questions or comments? If not, Vice Chair, HB 1208 as amended.
The Chair's recommendation is to pass HB 1208, HD1 with amendments. Chair and Vice Chair vote aye. Rep. Ichiyama.
Aye.
Rep. Kobayashi is excused. Rep. Lopresti is excused. Rep. Lowen.
Aye.
Rep. McKelvey.
Aye.
Rep. Nakamura.
Aye.
Rep. Takumi.
Reservations.
Rep. Todd.
Aye.
Rep. Tokioka.
No. No.
No. Rep. Ward.
Definite no.
No. All right, Chair, your recommendation is adopted.
Okay, thank you very much. HB 1209, income tax law. Again, the author has asked us to put in a explanation on the purpose of the bill. The bill is already defect dated. Members, any questions or comments? If not, Vice Chair as amended.
Chair's recommendation is to pass HB 1209 HD1 with amendments with previously excused members. Any members voting with reservations?
Reservations.
Reservations for Rep. Tokioka. Any other members voting with reservations?
Takumi.
Yep, I got you.
Okay.
Any members voting no?
No for Ward.
No for Ward. Okay, so I've got a no for Ward and reservations for Takumi and Tokioka. Any other members voting with reservations or no? If Chair, your recommendation is adopted.
Okay, thank you very much. HB 892, Law Enforcement Standards Board. HMSO notes that Section 2 of the bill is missing statutory amendments that were made by Acts 25 and 217 Session Laws 2021, which exempted HAIMA personnel and positions at the School Facilities Authority. And they also note that on page 12, line 20, there should be a space before 5 and it should be underlined. The AUG also recommends amendments to change the appropriation to $483,500. So, members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 892 with amendments noted to previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 893, law enforcement vehicles. The committee seemed uncertain about the need for this
measure, so we will defer this indefinitely. HB 2075, firearm permit registration. Chair's recommendation is that we move this out as is. Members, any questions or comments?
Chair?
Yes.
Yes, hi, no, thank you for the recommendation. I'm supportive of the intent of the bill. My concern is that this, this inspection piece has caused a lot of controversy and discussion, and that I'm a little nervous, given it's a single referral, about moving forward with a clean date because it doesn't allow potentially more time to discuss that. So I'll be going with reservations on the bill.
Yeah, Representative McKelvey, your concerns are well taken, and the chair will defect date the bill January 1st, 22.
Thank you so much, and please withdraw my WR.
Okay, thank you. Members, any questions or comments? Not, Vice Chair, as amended.
Chair's recommendation is to pass HB 2075 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no?
No.
No. One got Rep. Tokioka, no.
And
Rep. Ward, no. Any other members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 1867, liquor homicide. Members, there were a number of concerns with this measure, and so the chair recommends deferral. HB 1866, intoxication. The chair's recommendation is to defect date this January 1st, 2022. Members, any questions or comments? None, as amended, Vice Chair.
Chair's recommendation is to pass HB 1866 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 2337, related to substance abuse. Chair's recommendation is that we pass this forward with a defect date January 1st, 2022. Members, any questions or comments? Seeing none, Vice Chair, as amended.
Chair's recommendation is to pass HB 2337 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
The paper.
Thank you very much. HB 1878, related to the Supreme Court. I note that on page 1, line 3, session terms should also be underlined, as this is new language in the bill. And move this out with a defect date January 1st, 2022. Members, any questions or comments? Not, Vice Chair, as amended.
Chair's recommendation is to pass HB 1878 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 2049, the revision bill. Chair's recommendation is that we move this out as is. Members, any questions or comments? Seeing none, Vice Chair, as is.
Chair's recommendation is to pass HB 2049 as is, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, HB 2074 clarifies defendants may not earn credit on sentencing imposed for subsequent convictions. His recommendation is to pass this out with effective date January 1st, 2022. Members, any questions or comments? Seeing none, Vice Chair, as amended.
The Chair's recommendation is to pass HB 2074 with amendments noting the previously excused members. Any members voting with reservations? Rep. Nakamura with reservations. Any other members voting with reservations? Rep. Lowen. Any other members with reservations?
Reservations.
Tokioka, reservations. Any other members voting with reservations?
WR here too, if you don't mind.
McKelvey with reservations. Any other members voting with reservations?
Takumi, WR.
Takumi. Any other members? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 2422. Chair notes that technical amendments needed for clarity, consistency, and style. Defect date January 1st, 22. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2422 with amendments, noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, HB 2197, work in progress at the moment. Chair will defer decision making on this to February 10th, hearing on February 10th. HB 1179, course of Mauna Kea. This is a carryover bill, so we will make technical changes to the dates in the bill, and we will place the appropriation amount in the committee report. Members, any questions or comments?
Chair, a brief comment, if I may.
Yes.
The saying is generally success begets success. You begin with the easy ones and then you lead up to the increasingly harder things, so you have confidence along the way. I commend the author for this because it's very entrepreneurial, but it's kind of going to be one of the toughest things to make any money on or commercialize. So I think if it spurs entrepreneurial endeavors, which this will be, I would hope that that'll lead to others, but this is going to be a pretty difficult long shot in order to be able to make any money, at least given what I've learned from it just briefly with, talking with Mr. Ida. Perhaps I should talk to the author in more detail, but I commend the entrepreneurial effort that is behind it. Thank you.
Yeah, I mean, yeah, for what it's, sorry, real quickly, it's my fault. For what it's worth, I mean, worst case scenario, if it's not economically viable, you still do have that gorse removal. So kind of a win-win, but I appreciate your comment though.
Yeah, thank you.
I think the expression is a gorse is a gorse, a gorse, of course.
You'll be able to say that for 3 more years, report.
Of course.
Okay, members, any questions or comments? If not, Vice Chair as amended.
Chair's recommendation is pass HB 1179 with amendments noted the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 2028, raw milk. The chair notes that in the past year, goat's milk, which was being sold for pets, was also taken out of sale by the Department of Health. So the chair would like to add a new section allowing for the sale of goat milk for pets, in addition to raw milk for human consumption. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2028 with amendments. I'm just going to go down since I know we've had some discussion about this. Chair votes aye, Vice Chair votes no. Representative Ichiyama?
Aye.
Representative Lowen?
Aye.
Rep. McKelvey?
Aye, sir.
Rep. Nakamura?
No.
Rep. Takumi?
Aye.
Rep. Todd?
WR.
Rep. Tokioka?
Reservations.
Report.
With reservations.
Thank you.
Okay, thank you very
Your
much.
recommendation is adopted.
HB 2146, marriage licensing. Chair's recommendation is that we adopt the Department of Health amendment to charge all solemnizers $25. Members, any questions or comments? Seeing none, Vice Chair as amended.
Chair's recommendation is to pass HB 2146 with amendments noting the previous excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. HB 1903, Chair's recommendation is to delete section 1 and defect dated January 1st, 2022. Members, any questions or comments?
Chair, it's section 1 or 2?
Section 1.
Okay. And then in the committee report, are you going to note the online platform issue that was raised?
This is snorkels.
Oh, my bad. Sorry, I'm jumping the gun. It's my closed mask snorkel. It can't be all hot.
Of course.
Hey, members, any other questions on the snorkel bill? Okay, not Vice Chair as amended.
The Chair's recommendation is to pass HB 1903 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much. And finally, HB 1991. Chair's recommendation is that we delete section 3 and 4 from the bill and effect dated January 1st, 2022. Members, any questions or comments?
This is the one. Are you gonna, Chair, could I ask if it's possible to note in the committee report for the next committee, the issue of the online sales platforms, to have them perhaps examine it, making them more accountable?
Yeah, I will work with you on language for that.
Oh, thank you. Appreciate it, sir.
Any other questions or comments? Okay, if not, Vice Chair as amended.
The Chair's recommendation is to pass HB 1991 with amendments noting the previously excused members. Any members voting with reservations? Any members voting no? Chair, your recommendation is adopted.
Okay, thank you very much, members. We are adjourned.